Hello, boys and girls. Welcome back. So we were discussing various chapters in JIGL. Today, let us start new chapter, which is law relating to torts. Maybe most of you might have heard about tort, or for most of the students, it could be a new word as such. Reason it is not an Indian law. So tort is more famous, or tort is more specific law where you will be finding in UK. But still, the practice of tort is going in Indian laws also. Now, so what exactly is a tort? Where exactly it is applied? Now, if at all I have to give you one simple answer, tort is nothing but a wrong. Now, wrong can be of various types. It can be criminal wrong, it can be civil wrong. So when I talk about a tort, which type of wrong it is? It is a civil wrong, sir. So now you might be asking me, sir, what exactly you mean by civil wrong and what exactly you mean by criminal wrong? More about criminal wrong and civil wrong we will be discussing when we discuss chapters of CRPC, chapters of CPC and IPC. So there very detailedly I will be discussing about criminal wrong, civil wrong, etc. But for now, to complete this chapter in an easy manner, I will be telling you one simple example. So whenever we talk about civil wrong, their compensation is enough remedy. Compensation bolo, or if somebody is ready to pay you damages, that is an enough remedy. Then that is nothing but a civil wrong, sir. But where human rights are affected, where compensation is not an adequate remedy, then you say it is a criminal wrong, sir. So there generally there is a criminal liability also. For example, I enter into a contract with other party. Now I do not go as per the contract. Now because I have committed a breach, now can I say other party is going to incur a loss for that. Now for this, I guess other party, if at all he gets back his loss amount, he will be satisfied with this. So can I say this is nothing but a civil wrong, sir? Okay. So breach of contract, breach of trust are always civil wrongs. Imagine I commit a murder of another party, and after committing the murder, I go to the parent of that particular person and say, "Boss, I am ready to pay you the damages." Now, do you think the parent would be satisfied with this? No. Answer is no, sir. So, can I say in this case, damage is not an adequate compensation, or a damage is not enough, sir? So, can I say, as a situation may here, what we want is conviction of the other party, sir. Now, generally, we call this as a criminal wrong, sir. I hope to some extent you might have understood the difference between civil wrong and criminal wrong. Now, the question is, sir, you said tort is a civil wrong. So obviously, all criminal wrongs are excluded from the purview of tort. Next question. Sir, civil wrong may, do you think all civil wrongs are covered in tort? Answer is so. Tort is that type of a civil wrong which excludes your breach of contract or breach of trust. Okay. Now, for example, why they are excluded? Reason being very simple: breach of contract is a civil wrong, but that is anyway covered in your Indian Contract Act. So, when a particular matter is already covered in one particular law, so we thought let's not cover that in tort specifically. Okay. Now, so example, one more example I would like to take here. Now imagine a scenario. So say for example, real estate builder, sir. Now he has constructed one apartment. Now imagine construction may he has shown negligence, or he has used poor quality material for construction. Now as a situation may, can I say there is a breach of contract. So there was a contract between the builder and the party who has allowed the construction, sir. So there was a proper contract. Now here there is a breach. Now this is a breach of contract. Adequate remedy can be obtained through Contract Act. Okay. So this is one point, sir. Now say for example, second example I would like to take where I can cover this as a tort. Now you were driving the vehicle, and because of your negligence, or sometimes imagine without your negligence also, sir, you have met with an accident, sir, and it is you who were driving the vehicle. Now other party he will be hospitalized, etc. Now can I say here you call this as an accident? Reason being very simple: it was unintentional. But the point is, do you think you have to pay damages to other party? Answer is yes. Now here there was no contract between you people. but still you are supposed to pay the payments. Now this is what I mean by a tort, and this is what I mean by a civil wrong, sir. Okay, so this is a basic understanding which you have to have, and over a period of time I will be also talking about what are the essential elements of tort, what essential ingredients should be there to call as a tort, sir. So you will be understanding there are three essential elements, or you can say ingredients, to constitute a tort, sir. Okay, so let me start now with our main topic. So law relating to torts we are talking about. So tort is a French word. Remember, I just now I told you that tort is a law which is more prevalent in UK. Sir, law is prevalent in UK, but word is a French word, sir. Now, uska equivalent English word, if somebody gives me, tort is nothing but a wrong. Sir, wrong can be of two types: criminal wrong and civil wrongs. So which wrong tort covers? So tort covers only civil wrongs. Okay? Now, if at all you want to gain more knowledge about criminal liability, now remember, criminal wrong will have criminal liability, civil wrong will have civil liability. So if you want to know more about this, a specific video I have already uploaded on my YouTube channel, sir. Now I did not find any ways I should discuss all those things in this particular chapter. But yes, on your what you say personal level, if you want to watch this video, you can always. So title of the video is criminal liability versus civil liability. So I have discussed this from company law point of view, but for that matter you can apply the same what you say fundamentals for any law as such. Okay, and I request please do go through this particular video. You will understand more specifically what exactly I mean by civil liability and what exactly I mean by criminal. Maybe some students are of an opinion, sir, whenever monetary damage is there, that is a civil liability. Whenever monetary damage is not there, that is a criminal liability. Answer is no, sir. Small twist is there in there also, so please ensure that you go through, sir. Okay, so that was one point which I wanted to talk about. Now let's come back to our main discussion. So I said tort is a French word. English equivalent meaning is wrong. Wrong are of civil two types: civil wrong and criminal wrong. And tort will only cover civil wrong. Question is whether all civil wrongs will be covered. Answer is so. Tort is a civil wrong which is not exclusively breach of contract, breach of trust. Meaning, even this is also a civil wrong, which is also a civil wrong. Breach of contract, breach of trust is also a civil wrong, but that is not covered in tort. Reason I told you, it is already covered elsewhere in other laws. So, in other words, can I say civil wrong is a superset which also has something called tort, which also has something called breach of trust oblique breach of contracts. So can I say tort is a subset of what? Civil wrong? Is it a appropriate line? Yes. So tort is a part of civil wrong. Okay, so that is what it is. Simple way mein, if I have to tell you what is a tort. Now this is a simple definition we are talking about, sir. If it applies, if मतलब क्या tort है ना? So if it applies to a human context, anything which a human does which is contrary to a law, inconsistent to a law, is nothing but tort, sir. In other words, law is saying you something, you are doing contrary to that, inconsistent with the law, then that is nothing but a tort, sir. Okay, so that is what you have to understand. So what is the inference conclusion you can get from the definition? Now remember the definition which we have written here or studied here. I told you there is no specific law, exact law called a tort, sir. Okay, we are just relating all the concepts relating to tort, sir. Now the definition of tort we have borrowed from Limitation Act. So section 2 clause M of Limitation Act 1963 defines the meaning of tort, sir. Okay, so ensure that in exam you don't write as per law relating to tort or as per section 2 of tort. So examiner will be really surprised saying that section 2 of law relating to torts. ऐसा कोई law नहीं है and ऐसा कोई section number नहीं है. So this definition we have borrowed from Limitation Act 1963, sir. And this is covered in your CS material also. Whatever video I am recording, sir, now this is more apt for CS executive students also and students who are doing LLB, sir. Now this law you don't have in CA exams and you don't also have in CMA, sir. So this is a law more specifically for all those people who are doing their LLB or for those people who are doing CS executive. So CS executive may JIGL people. Anyway, you know this point, sir. Now, so most of you people who are doing CS, they simultaneously also do LLB, sir. So if at all you have this proper explain understanding, sir, you can apply the same in your LLB paper also, sir. Okay. So what is the inference we get from tort? So tort is a species of a civil injury of wrong other than criminal wrong. Already we know this. Every civil wrong is not a tort. Already we know this. But a tort is a subset of that. So can I say these are the three inferences which we have already understood. Okay. Sir, to constitute a tort, to constitute that civil wrong, sir, now what are the ingredients? Now, every tort may, these three elements are there, sir. Every tort may, these three elements should be. So, what are those three elements? First element is there should be a wrongful act. In other words, if at all you say Mr. A should be punished for a tort, if at all you say Mr. A has committed a tort or Mr. A has committed a civil wrong, okay, which civil wrong we are talking about? That civil wrong which constitutes a tort. If at all you say Mr. A has done that, so obviously this tort should have these three things in it. More examples of tort also I can give you is, say for example, sir, using abusive words is a tort, sir. So you are using beep beep words and em matladutunnavura maida pindi. How can I say most of the Telugu people will understand this, sir. So can I say if at all you use such abusive language, can I say this is also a tort, sir? Okay, moving forward we will try to understand. Sir, filing a wrong case on the other party, that is also a tort, sir. So you are trying to file a false case on the other party so that other party ka reputation comes down, that is also a tort, sir. So using beep beep words, I told you that is nothing but defamation. It is called, sir. That is a tort, sir. Unnecessary, you beat somebody, sir. So bodily harm you try to cause, or you give shock to other parties, sir. So all these are nothing but examples of what, sir, tort. So they all are civil wrong, and which branch may they are covered? They are covered in tort. Okay. So that is one small example which I told you. Now, before I discuss these three elements, है ना, उससे पहले एक छोटा सा point I would like to discuss with you people. Generally, I am saying, sir, in India, in India, if any person's act is to be called as an offensive act, in other words, if a person does any act, if that act is has to be called as an offensive act, then one of the most important thing what we see in that act is presence of menseria. Presence of menseria. Again, if at all Mr. A has committed an offensive act, so what generally we have to check in that offensive act, all Indian laws may, this is what we try to check, whether that act is having any presence of menseria. If yes, then that act is an offensive act and he is liable for punishment. He is liable for punishment. So, in other words, an act by itself does not become an offensive act. So, एक act में what is the most important thing we have to see, sir? Act मतलब क्या? Action. So, any of your action is what we are talking about. Any act में what is that we are trying to check, sir? Mens rea. And if that is there, then that becomes which act, sir? That becomes an offensive act. And then that is liable for punishment. Okay, sir, very nice. Now, if at all you feel that this is worth enough writing, sir, you may pause the video and write simultaneously with me. So maybe I can wait for half a minute, sir, and then proceed. Okay, so I'm just waiting. You may pause the video and note it down. So I hope you might have done that, sir. Okay. So an act has to be called as an offensive act. Mens rea is must. But sir, in the case of tort, if at all we are talking about a tort, sir, we are not bothered about mens rea. In other words, even if a person commits an act and because of that act, other party gets a legal injury, other party gets what, sir? Legal injury. So you have committed an act. Obviously, that act is a wrongful act. Obviously, that act is a wrongful act. And because of the wrongful act, other party gets some legal injury. Whether or not you had mens rea, still you have to, and still that act of yours will be called as tort, and you will be liable for punishment. That is, you are liable to pay damages. Example. Now I was driving the vehicle. Okay, I was driving the vehicle. Now I was driving the vehicle. चलिए, so I was driving my car, sir. Not at all a problem, sir. Now imagine suddenly आगे से मतलब maybe ignorantly or whatever manner में this person है ना, he came in front of my car, sir. And next scene what happened is this. So this person है ना, now all 3D effect. Now this person has met with an accident. Okay. Now, the point is, when I was driving the car, intentionally I did not hit him. Now, most important point I forgot to explain you. What is mens rea? Sir, mens rea refers to guiltiness in mind, or you can say guilty mind. Okay. Example, sir. Sir, anything which you do intentionally, purposefully, with a wrongful intention. So this is wrongful intention, then that is nothing but mens rea. Okay. So you are not doing with bona fide intention. You are doing this with malified intention. Then that is a mens rea. Example, sir. Now, Kasab, Daud, whenever they murder any person, whenever they attack any particular country or any particular area, sir. Now, can I say they are doing this accidentally or intentionally? Answer is intentionally. So, whenever they do this, now can I say there is a mens rea, and obviously there will be a guiltiness of mind, sir. In other words, they are having a wrong intention behind committing that murder, and hence we say there is a presence of mens rea. Okay, so killing the person was an act. Killing with a wrongful intention, then there is a mens rea, and hence it becomes a offensive act, and hence he is liable for punishment. समझ में आया? So you murder with a wrongful intention, then mens rea is present, sir. So that becomes a offensive act, and hence there is a guiltiness of mind, sir. Okay. Similarly, say for example somebody was trying to attack you, sir. Now in protection of that, you have taken the weapon, and now you have inserted the weapon in the other's body, sir. So can I say you have also done a wrong, you have also done an act, but there mens rea is not present. You have not done this intentionally, है. So here I cannot call this as offensive act, because this you have done to protect yourself, है. So this is a legal remedy which is allowed in the law also. So आगे जाकर I will tell you there are some remedies which are legal remedies, and they are judicial remedies, extrajudicial remedies. So extrajudicial remedy में, है ना, if at all you try to safeguard yourself, है ना, then that is a remedy which is allowed as per the law. I hope you are able to understand. Okay. So similarly, when I was driving a car, sir, suddenly है ना, मतलब maybe मेरा आंख बंद हो गया sir, है ना, I मतलब just I lost my concentration and एक accident is made, and because of that accident if somebody is injured, है ना. So now my question to you people is, sir, accident is a act. Now, sir, now the point is, this injury के लिए should I be imprisoned? Now the point is, this act has happened, but can I say what was present, what was absent in that? Mens rea was absent. Now, if mens rea is absent in that, then that is not that act which you say is an offensive act. That is not a criminal liability. That becomes a civil. I hope you are able to understand. So now my point is this, sir. So because there is so to punish a particular person as per Indian law, what is must? Mens rea is must, sir. But in tort, even if menseria is there or not there, sir, can I say you are supposed to pay damages? You are supposed to pay damages. So damage is what you have to always pay. So just because I have committed an accident, yes, that is understandable, sir. Menseria was not there, but that doesn't mean you need not pay the compensation. You have to pay the compensation. So this is what the speciality of what bacha taught is. Okay. So what exactly I was trying to talk about. So first I explained you the meaning of menseria. Menseria is nothing but guiltiness of mind. An act by itself does not become an offensive act. An act becomes an offensive act if there is a guiltiness in mind or malified intention, which is called as menseria, sir. Okay, very good, sir. In DMA, if at all you have to punish a person, sir, what compulsorily required is menseria. However, if it is a case of a tort, if it is a case of a tort, even if menseria is not present, still a person is liable to pay damages. This is the speciality of tort. This is the speciality of tort, sir. Okay, so this is one small understanding which you should have. Now, I guess we can proceed further. Now, whatever important points, if at all you feel I am uttering, sir, you may write down. Anyway, these all points are there in your material also, sir. So we have given you a well drafted material. So you can see everything is mentioned and menseria point is also mentioned. Okay. Now, while discussing, I will discuss these points. Not at all a problem. So now let us discuss. So from material, first question we have covered. What is the meaning of tort? We are done with this. So section 2 clause M, limitation act may, this was defined, which we have already covered, sir. Now let us discuss second question, which is general conditions of liability for a tort. Clear, sir. So to constitute a tort, what are the three elements? In other words, if these three are there, then that is a tort. Otherwise, it is not a tort, sir. Okay. So, what are the three ingredients? Let us see. Okay. So, first thing is there should be a wrongful act. There should be a wrongful act. So, there should be some omission of the defendant. Now, plaintiff and defendant, I guess you understand the difference. Sir, anybody who institute a plaint, anybody who files a case in the court, that person is called what, sir? Plaintiff. Okay, so he is the one who initiates the matter in the court. Sir, on whom he is filing the case, that person is, because he has to defend that. Okay, so if I pass one allegation in the court, the other party has to defend himself. That's the reason we call this person as defendant. Next point. Generally, plaintiff is the sufferer. Generally, plaintiff is the sufferer. Why I'm using a word generally? And I will tell you. And defendant is the wrongdoer. Now, if I have to tell you in tort language, he is called tort feeser. He is called what, sir? Tort feeser. Okay. So now tell me, sir, wrongful act who will commit? Wrongful act plaintiff will commit or wrongful act defendant will commit obviously defendant will commit, because if defendant does something wrong, then only plaintiff will file a case on that. So there should be a wrongful act or there should be a omission which is done by whom? Defendant. Okay, some wrongful act, some omission is done by defendant. Okay, and who is the defendant, sir? I told generally he is the wrongdoer. So why I'm using a word generally? Generally sufferer is the plaintiff. Sometimes what may happen, sir, even if you have committed the mistake, even if you have committed the mistake, you yourself might file a case in the court. Huh? So ulta chor kotwal ko date, this is what generally we say, sir. Huh? So tappu meedi kaadu, you did not do anything wrong, sir, but still other party is filing a case on you. So this is nothing but a false case which has been filed on you. Now aage jakar, now I am using a word false case, but moving forward I will name this as malicious prosecution. I will name this as what, sir? Malicious prosecution. In other words, even though mistake is committed by you, even though mistake is committed by other party, in fact, you should file the case, but here other party is filing a case on you. and that is a case of malicious prosecution. Okay, so moving forward, I will discuss this. Even doing such thing is also a tort. So moving forward, I will discuss. Let's not confuse things. So to constitute a tort, three things are required. First, wrongful act. Who should do this wrongful act, sir? Tort feeser or defendant or wrongdoer. Okay, very good, sir. Sir, that wrongful act should cause you something, no? It should bring some legal damage. It should cause injury, legal injury to other party. Okay. First, there should be a wrongful act. Because of this wrongful act, other party ko legal injury should be there, sir. Some legal damage should happen. And for that legal damage, there should be a legal remedy. And that legal damage should give rise to a legal remedy. If these three things are there, then we will call this as a tort. First, person should do a wrongful act. That wrongful act should result into legal damage to the other party, and that legal damage should have a legal remedy. That legal damage should give rise to a legal remedy. If these three things are there, then that is a tort. Okay. So let's explain all these 3 points step by step. Let's understand this step by step. 1 minute. So taught me, first thing I said, there should be a wrongful act. Okay, and that wrongful act should result into legal damage, or that should cause legal injury, and that legal injury should give rise to a legal remedy. Okay, so in every tort, these three things you will understand. Okay. Now, what is a wrongful act? I already told you, sir. It is any act which is contrary to the law. It is any act which is contrary to the law. Meaning, your country law is saying something and you are doing opposite of that. That is nothing but a wrongful act. That is nothing but a wrongful act. Disrespecting national anthem is a wrongful act. है ना? So counterfeiting notes is a wrongful act. Counterfeiting note मतलब जाली note है ना? What do you say? Banana. It's a wrongful act. So anything which is contrary to a law is a wrongful act. But now we are talking about ingredients of law. Now that contrary to law should cause legal damage or injury to other party. Remember, when we say legal injury or legal damage, here what we are what we are not bothered about, what is not important is monetary loss. Monetary loss is not important. So what is important? Legal damage, legal injury should happen. That is more important. So here, itna discussion is not there, but here, for a detail, we will discuss. Now, to understand this, we have two citations in our material, sir. What are those? One is Damanun, Sine, Injuria versus Injuria, Sine, Damanun. Okay, now, sir, what is this point, sir? Injuria matlab injury, legal damage. So here you can write like Sine matlab without, and Damanun matlab क्या sir? Damage. Damage. Which damage we are talking about, sir? Monetary loss. Okay. So monetary loss we are talking about. So here also you can say this is nothing but monetary loss is what we are talking about. Okay. So presently point A is done. Now let's discuss point number B thoda detail. Expect one question from this particular area in max to max. This chapter is a chapter of about 6 marks to 8 marks in exam. if at all we are talking about CS executive, sir. Now LLB mein to it is altogether a big, what you say, chapter in our what you say, exam. So I passed this LLB. So exam mein sometimes it comes for 10 marks, 12 marks, and you get some essay questions also, sir. So different universities mein different pattern, paper pattern is there, sir. Okay. So LLB, so obviously you have to take entire thing very seriously. But for executive students, this is the most important question. So chances are very very bright you read entire thing in this chapter, but this question is the most important question. If you take past year papers, you will be finding multiple times question has appeared on this particular matter, sir. Now, so what is this point, sir? Okay, अब ध्यान से सुनना what I am trying to tell you, sir. Now first example I will take is of competition. Okay. Now India is a land of traditions. Now most of the time, matlab, there were days we used to have something called joint family. Now also we find, but can I say now percentage of people living in joint family is very very less. Can I say nuclear family ka zamana hai, sir. Okay, thanks to your modern wives, or for that matter modern husbands also, where proper understanding is not between the families. Anyway, so joint family tha. Imagine joint family was this. So you had grandfather, grandmother, and then grandfather ka, what is say, sons we are talking about. Imagine grandfather, and down they have, imagine three sons. So son number one, son number two, son number three, sir. Okay. So you people are below it. So presently, say for example, grandfather was having one textile business. Okay. So he was having one textile business and he was running somewhere, say for example, in Banjara Hills. Now, Banjara Hills one is one place in Hyderabad, sir. Okay. So 50 years, what you say, standing is there in the market. So can I say obviously they will be having a good following, or better thing what I'll do is sort of practical example, let us take. Say for example, we are talking about joint family where Karachi bakery we are talking about. Okay. So somewhere in Mozamzai market, or if in Hyderabad they are having this bakery shop, sir. Okay. So can I say since what you say independence they are carrying their shops, sir. So this is a very famous brand. Okay. Now grandfather ke baad these three people are collectively, three sons are collectively running this shop. Now imagine these people are married now, and because of marriage internal disturbances have occurred and now they want separations. So what has happened now? Now can I say son one is continuing that shop, Karachi bakery. Now son two, what he does is he opens a, or let's say like this, son one and son two are continuing this shop, sir, and son number three he opens a new shop now, and he writes new Karachi bakery. Ekdam opposite the banner is. Now, don't you think because of this, what will happen, sir? Earlier, if say for example, thousands of customers were going here, do you think few customers will get diluted here also? Answer is yes. And definitely few customers will get diluted there. So maybe and chances are bright, 600 customers are going here and 400 are going there. Do you think here this Karachi bakery ka owners, that is S1 and S2, will they get any monetary loss? Will they get any monetary loss? Yes or no? So obviously your answer is going to be yes. Okay, very good, sir. They are getting a monetary loss. So now my question to you people is, can they go to court? Can they go to court and ask for any legal remedy? So समझकर बोलना, can they go to court and ask for any legal remedy? No. If at all they want any legal remedy, now question is on what basis they will ask this legal remedy. So they will say because of this competition we are losing our profits and hence I want to file a case on other parties. Do you think court will entertain this? Answer is why? The can I say competition के वजह से there will be obviously a monetary loss. today Santri has opened this, maybe tomorrow somebody else can open this. So can I say you are filing the case, you are filing the suit in the court on what basis? Because you are losing the profits because of competitions. Do you think is this a tort? Answer is no. So here, what is that you should understand? Here, monetary loss, Damanun, did it happen? Answer is yes. Monetary loss has happened, sir. But do you think any legal rights are affected? Answer is no. Answer is no. So can I say Damanum Sine Injuria? So don't you think here there is a monetary damage without legal damage? There is a monetary damage without legal damage. So do you think is this a tort? Answer is no. It is not a tort. It is not a tort. I hope you understood this point, sir. Clear, bacha? Next. So I can take various example, but I thought, if at all I take very simple example, easily you can understand. Okay, one more example I will take, sir. Example number 2. Okay, now, so maybe most of the students who are watching this video, you all might be adults. That doesn't mean any adult content is there here. So all you might be major, on a better word is major. So आप लोग major होंगे. That is what I am expecting. Now, sir, maybe all you will be having the voter ID cards and you will be having right to vote. Okay, now, sir, imagine a scenario, and whatever examples I take, they are only example. Do not take them seriously. Okay? तो इस क्लास के सभी एग्जाम्पल्स काल्पनिक है, जिसका वास्तविक जीवन से कोई समानता नहीं है. अगर वास्तविक जीवन से इसकी समानता होती है तो ये मात्र एक सहयोग कहा जाएगा और पीजे उसकी रिस्पॉन्सिबिलिटी नहीं लेगा. So all the examples in my classes are merely fictitious one which has no resemblance to any living or non-living beings. If any resemblance is found, it is purely coincidental in nature and PJ is not responsible for that. And PJ means myself, Praveen Jain. Okay? So just examples. Sir, imagine one of the student. Okay? एक मेरा student sir. So imagine Chintu is what his name is. So he is going to polling booth for voting. So some polling booth में he is going for voting, sir. So outside polling booth, imagine somebody is standing. You may say that I am standing, sir. Okay? I am standing there. Okay, very nice. Example है, again I am telling you multiple times I am telling you just example है. Okay sir, very nice. So now वो student को मैं देखा सर, है ना, बोला मैं ए चिट्टू इधर क्या कर रहा है, तो ही इज लाइक सर आई एम गोइंग टू वोट सर. किसको वोट देगा, है ना, यू विच पार्टी को यू आर कास्टिंग देयर वोट सर. तो इज लाइक मैं हाथ को वोट देगा. हाथ को वोट देगा मतलब कांग्रेस को वोट देगा सर. ओके, वेरी. नाउ आई स्टार्टेड टेलिंग दैट अगर तूने हाथ को वोट दिया, जिस हाथ से तू वो वोट देगा उस हाथ को काट कर मैं दूसरे हाथ में दे दूंगा. तो हियर आई एम ट्राइंग टू टेल. तो वो स्टूडेंट बोला सर पर किसको देना, किसको देना, कमल को दो, है ना. तो कीचड़ में खिलता है कमल, तो कमल को वोट दो. So now don't you think sir I am trying to influence the voter? Don't you think I am trying to influence the voter? Answer is yes. Can I say here, did this student get any monetary loss? Did this student get any monetary loss? Answer is no. He did not get any monetary loss. But do you think right to vote is his legal right? Right to vote is his legal right? Answer is yes. And which party ko he can vote, do you think that is also his legal right? Answer is yes. He is having full freedom to select which party ko he wants to vote, whether to vote or not, that is also his selection only. Agreed or not, sir? So can I say here he wanted to vote for X party, I am forcing him to vote for Y party. Do you think his legal rights are affected here? Answer is yes. So here what is the word I have to use, sir? Legal rights. So here I have to use the word legal rights are affected. And if legal rights are affected, do you think in court, will he get any legal remedy? Answer is definitely. So if he goes to police station and files a case on me, do you think police people or the police station or legal remedy is available for him? Answer is yes, because his legal rights are affected. his legal rights are affected. Agreed? So can I say for a tort, what is more important? Damage to your legal rights are or monetary loss? Damage to legal rights, or you should get legal damage or legal injury. That is more important. So can I say whatever that voter IT example I have taken, that is nothing but Injuria Sine Damnum. So here there is a legal damage without monetary damage. Legal damage, legal injury without monetary damage. So now tell me, sir, for a tort, what is more important? Damanum sine injuria or injuria sine damanum? So my answer would be injuria sine damanum is more important than damanum sine injuria. I hope you understood this. So this is the conclusion which you have to give in your exams. Okay. For a tort, what is more important is injuria sine damanum. Now there are various ways of pronunciation, and so maybe some authors will say sine and a sign. So damanum ko some other way they may pronounce it. At the end, pronunciation is not that important, and understanding concept is more important. If at all you can understand through pronunciation, that is okay, and that is all right, not at all a problem. Okay, so I hope you understood this with example. Now, or an example I would like to give you. Now, say for example, you are living in your house. Now, I come to your house and I sit in your house. Okay, so I'm sitting in your house. You were watching the TV, and I am also watching TV along with you. Now, I am not known to you people. Okay, now this is what it happens in virtual world. And who is watching this video? I don't know. So if one particular student, one particular person, the house, I go sir and I sit beside him, or what is it, beside him on other sofa, and I sit and watch the television. So my question to you people is, and I am keeping calm. I am not doing anything. है ना मैं कुछ नहीं कर रहा हूँ एकदम साइलेंट बैठा हूँ So my question to you people is will you be happy sir will is this okay for you people? I am unknown to you people. Obviously what you will say sir निकलो इधर से निकलो imagine I am not going out sir now whenever you say निकलो इधर से leave the house I am smiling at you sir. 440 वोल्ट का है ना स्माइल आई एम गिविंग टू यू पीपल बट आई एम नॉट लिविंग द हाउस so now my question to you people is if you call the police officers do you think will they help you now the point is, I did not damage you anything. I did not beat you. I did not scold you. I did not utter even a single word. I am smiling at you people. But still, do you think police people will help you? Answer is because this is also a case of injuria sine damnum. Here, what has happened is trespass. What is trespassing, sir? Others' property may, if you are trying to invade without his permission or her permission, this is nothing but act of trespassing. This is nothing but act of trespassing. And obviously, when there is an act of trespassing, sir, can I say others' property, others' property may person who was having legal rights, his legal rights are getting affected. So can I say here also legal rights are there, but monetary damage is not there. But still, this is enough to constitute a tort. समझ गया बच्चा? I hope you understood the second example also, third example also for that matter. And last May, we are talking about what bacha? Legal remedy. Now, what is legal remedy, sir? Remedy in the eyes of law. Okay. Now, legal remedy are of two types. Now, we are discussing third element. Legal remedy are of two types. One is judicial remedy. And one is extrajudicial remedy. Legal remedy are of two types. One is judicial remedy and one is extrajudicial remedy. Now, when I say judicial remedy, it means what? This remedy. Which remedy? Say simple है ना. A person is being suffered with some wrongful act, and that wrongful act has caused some legal injury. So obviously, he will go to court or he wants some remedy. Now, if this remedy he will get through judicial process, then that is what I mean by judicial remedy. If he gets this and out of judicial process, that is what I mean by extrajudicial remedy. In other words, to get the remedy from that wrongful act, and a judge ka intervention, courts ka intervention, law and order ka intervention is not there. So these are given by law itself. These are such remedies which are given by law itself to you people. So simple hai, if somebody is trying to trespass, so you always have the authority to throw them out of your house, sir. So can I say throwing them out of the house, is this also a wrongful act in the eyes of law? Answer is yes. But can I say this wrongful act you are doing to protect your properties? So can I say this extrajudicial remedy is allowed? So similarly, somebody is trying to murder you, sir. So can you also take a knife and what do you say, kill the other person to protect yourself? Answer is yes, because here you are trying to safeguard yourself. This is also an extrajudicial remedy, sir. So can I say here to what do you say? Imagine if teasing case is happening, sir. Okay, so if teasing case is happening, sir. So if one boy or one girl is if teasing the other party, can I say girls can also if tease? All possible. So if one girl is if teasing another boy or one boy is if teasing another girl, sir, so don't you think they can tell that, if at all doesn't listen, they can slap also, sir. So can I say this is a remedy which is allowed to you? Do you think for slapping will you go to court and take the permission? Answer is these are extrajudicial remedies. Okay. So here what I am done with question number 2. Now one is already explained, 2 is already explained. So can I say to constitute a tort, three things are there: wrongful act, legal injury or legal damage, and that legal injury or damage should give you legal remedy. Now, can I say in legal injury, I have discussed two things, sir. One is Damnum Sine Injuria, and next is Injuria Sine Damnum. And what is more important in tort is Injuria Sine Damnum. Okay, and I took one example of competition. Agreed? So in business, if there is a competition, then that is not a tort. Did I use that example or not, sir? So that was a decided case. That was a decided case in Gloucester grammar use case. So if at all possible, please remember the citation, and it would fetch you good marks in exam. So I took one example, no, that joint family example where son number 3 is opening a new Karachi bakery and trying to get the customers. So can I say son 1 and son 2, they are losing the customers because of heavy competition and they are getting losses. Can I say there what was there? Damage was there, monetary damage was there, but legal rights were not affected. So that case law was nothing but this particular case. And what you will be getting is legal remedies. Now, remember, after reading this point, sir, you have to write link to question number. If I'm not wrong, it is 10th question. Yeah, link to question number 10. In other words, here legal remedy only part is covered. Now, detailedly we will cover this in question number 10. This I was using for previous class people. Okay. So question number 10 may detailedly we will discuss all those remedies. I told you remedies are of two types. One is judicial remedy and one is extrajudicial. So more detailedly I will discuss this in next class. Okay. So I hope you understood this particular concepts. Okay. Very interesting chapter this is. In fact, all your chapters in your JIGLs except one or two chapters they are dry. Otherwise, all chapters are entertaining. Okay. So it is a very high scoring subject in your group module number 1, sir. So module 2 may, so there will be some other papers we are talking about. Module 1 may, out of those 4 papers, if any paper is a scoring paper, then this is the paper. You should always look for exemption in this particular, what is a exemption or more than exemption in JIGL papers. Okay, very easy. And good thing is what? No chapter is having any interlinkage except the CRPC, IPC. So these 3 chapters we will discuss in a cluster. Otherwise, all chapters you can read in an independent. Okay, so this is PJ signing off. Next class we will discuss remedies in tort, which is judicial also and. Okay, thank you, sir.